To be sure. So how tightly wound are these cases and these men? Neama Rahmani is back with us tonight, former federal prosecutor and president of West Coast Trial Lawyers. Neama, he just ended there. Trump and Nada work together. They're together all the time, but they're not allowed to discuss the case. It's a condition of their bond. When you're with somebody all the time and you're in private, who would know? If they talked about this over a Diet Coke, then what?
Chance, no one's going to know, and this is one of those judge's orders that, frankly, may not really be enforced. What you don't want witnesses to do, or especially co-defendants, is to talk to one another, tailor their testimony, and especially when you have an employer-employee relationship like this. But, you know, Walt Nada is either going to go down in history as a hero or one of the world's dumbest criminals, because he clearly had an opportunity to cooperate with the Department of Justice. He's turned that down. Now he's wrapped up in this indictment. We thought when there was a conspiracy, we might have some unindicted co-conspirators. I don't think many of us thought that there'd actually be a co-conspirator like Nada who's wrapped up in this indictment because he or she didn't cooperate.
So if your boss tells you, take this box to the attic and then move it to Bedminster, because we heard that they might have been shuffling these things around, and you know it might have something questionable in it, but you don't know exactly what, that's illegal?
Well, it is illegal, right? If you're willfully transporting classified materials, and the text messages show that he knew that these were classified materials or national defense materials, that's a crime. My boss told me to do it is not a legal defense. Now, practically speaking, I don't think Special Counsel Jack Smith or Merrick Garland, who had to approve this indictment, would have indicted Nada had he not made the false statements, had he not moved the boxes, and participated in this conspiracy to obstruct justice and to tamper with grand jury evidence. I mean, that's sort of taking it too far. Just like the whole reason Donald Trump has been indicted. If he complied with the National Archives and they didn't need more than a year to get these documents and had to resort to a grand jury subpoena and ultimately a search warrant, I don't think we would be here. Nada went too far, and that's why he's indicted as well.
I see. And is there any concern about, like, do you think at the end of the day, they're wondering, will the public be like, we got him, we got Walt Nada, you know? Was this worth it to go after him?
I don't think if we're talking about Walt Nada, we'd be here right now talking about this case. Donald Trump was going to be indicted. Walt Nada is alleged to have made false statements to the FBI and other Department of Justice officials. And since Trump was going to be indicted, and here's someone who's culpable as well, he got wrapped into this indictment. But I think if Donald Trump were to be dismissed for some reason, I don't think the Department of Justice is going to keep this case to go after Walt Nada alone.
Okay, so in the end, it became a BOGO of sorts, probably unfortunately for Walt Nada, and these men are now co-defendants. If they have these cases together and they don't end up being severed in the end, who does that benefit? Like, who comes out on top by having them interwound?
Well, it's really not good for Walt Nada, because I can't imagine a circumstance where Donald Trump is convicted but Nada gets a walk or he's acquitted. I mean, he's someone who is wrapped up with this with the president. And you have a situation now where Donald Trump is not going to take any type of deal, nor do I expect the Department of Justice to offer any type of deal. The vast majority of criminal cases resolved before trial through some sort of plea agreement, but this is not your typical case. So now Nada is along for the ride. He certainly doesn't have the president's resources. He just certainly doesn't have the president's money. And it's unclear who's going to pay for his legal defense, but these federal criminal trials are expensive. Lawyers are already hesitant to take this case because Donald Trump is a very difficult client in terms of paying his legal bills and listening to his lawyers. So now you have Nada trying to find a lawyer who's willing to go up against the Department of Justice and Special Counsel Jack Smith. That's not going to be an easy task.
So we're getting a little bit of a sense of maybe the defense strategy. Axios laid out a few motions they're hearing the defense might file, including one that the prosecutor in this case allegedly brought up to Will Nada's lawyer, that they had recently applied for a judgeship. Is that out of bounds?
Well, ultimately, really, it's up to Judge Cannon to decide who is going to what legal arguments are fair game and what isn't. I mean, we've seen some of this on Truth Social, right? That the documents were declassified, right? That this is all a political witch hunt or selective prosecution. Most judges would exclude those types of legal arguments from the jury as non-meritorious, right? So Judge Cannon, though, has taken a little bit of a broad view. You know, we saw with how she handled the executive privilege argument. She appointed a special master where a lot of judges wouldn't, and ultimately the 11th Circuit disagreed with her. So if she's going to say, hey, anything goes, she may allow this type of defense. But again, I don't think most district judges would. It just really has no bearing on the facts and law and the evidence in this case.
Mm-hmm. Another angle here, Mr. Trump argued last night that he had sole discretion when it comes to presidential documents, including whether he takes them with him after he leaves office or not. He did not point to a law that gave him that authority, but that's what he said. If he filed a motion challenging the search warrant in the first place, because, you know, if I have my diary in my house, the feds can't rush through the door and get it because it's mine, and that's what he's saying. Would that go anywhere if he makes that motion?
I don't think so, but here's the problem with that argument. First, you don't follow the proper protocol. You need to notify the relevant department head, and there's a procedure that has to take place before documents are declassified. But more importantly, if this legal argument fails, if Trump isn't able to prove that the documents were declassified, guess what? He's admitting knowledge that the documents were classified and the intent to keep them. That's not what you want to do if you're a criminal defendant. You're really sort of going all in on this legal argument, and if it fails, really you've established two of the most important elements of the crime, the knowledge and intent, which is not what you want to do.
Okay, so Neama, what about, you know, we've heard from the former president complaining that his lawyer's notes were improperly used against him. Like, apparently his lawyer, Corcoran, spoke into his iPhone, and then it was transcribed, and then the feds got their hands on it. And in it, he recalls that the former president said to him, like, why don't you pluck out the bad stuff, you know, or why don't we delete stuff like Hillary Clinton's people did? And the New York Times calls these notes the prosecutor's roadmap in the end. Could those be challenged?
I think so. I think this is one of the best arguments that Trump and his lawyers have. I know a DC judge has said that they're subject to the crime fraud exception to the attorney-client privilege, but generally speaking, the attorney-client privilege is the broadest privilege under the law. It's subject to the greatest protection. So rarely do those types of communications or they disclosed, much less admitted as evidence at trial. You know, here, of course, you have the prosecution arguing, though, you can't use your lawyer to commit a future crime or an ongoing fraud. And a judge in D.C. bought that argument. But again, we saw how Judge Cannon views these privileges. She's taken the opposite approach, right, with respect to the executive privilege, which is much more narrow. She said, well, hey, maybe these documents are subject to the executive privilege. If she's analyzing them under the attorney-client privilege, she may well say these notes are privileged, I'm not letting them in, and I'm going to exclude them. That D.C. judge's ruling is not binding in this case. That just goes to discoverability, but this is admissibility at trial.
Wow, okay. And those, like they said, those could be the blueprint. So let's see. Very interesting to circle back to Nada there, how you say that, yeah, he is a target. He's not big enough to where they might cut a deal with him. He's not insignificant enough to where they're going to just let him go. So sounds like a double bind. Neama Rahmani, as always, thanks.
Thanks for having me.